A very good morning to the e-viewers and the audience at the e-platform of Faculty of Law GLS University. Today, we are here to mark the very first event of IP Law Clinic for the current academic year, that is a webinar on emerging aspects of intellectual property law. Today, we have with us Dr. Rohit Moonka, who is Campus Law Center, Delhi University Assistant Professor. But prior to starting, let us take some blessings from the piousness of a small prayer.
कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्
Today, the topic for or the theme for the event is emerging aspects of intellectual property law. Intellectual property law or IPR status has various aspects like patent, trademark, copyright, GIs, and they have the strength and power to develop and innovate the world around us. We can see in the fields like medicine, intellectual property like biotechnology, biopiracy, patents, royalties, and so on, in which we can see so much advancement owing to the intellectual property advancements. Today also, we have chosen a topic which is bioprospecting and its traditional knowledge aspects and the correlation for that. But prior to that, let us have a welcome address. I request Dr. Vidisha, Assistant Professor and Coordinator IP Law Clinic, to formally give a welcome address. Please, ma'am.
A very good morning to each and everyone. Dr. Mohit Moonka, sir. Thank you so much. As Urvashi ma'am rightly stated, that the academic year has just started, and with a very high energy, we are having the very first event of our IP clinic. So, with a very heart welcome, we are welcoming you. Thank you for, sir, accepting our invitation. And as we all are aware that IP is contributing enormously in the field of innovation and creation in the economics and everything to the nation at the international level, national level. So this topic of today will enlighten the student with number of aspects. We have seen that when it was a lockdown, there was some slowdown in the litigation, IP litigation. But now again in 2021, we have seen that the IP litigations have tremendously increased. At national and international level, everything is again in the progress in the IP sector. So, sir, we heartily welcome you, and we are sure that the student will be enlightened by the very emerging topic which is there. So, thank you once again. I also heartily welcome all the students who have joined, students of IP Law Clinic, and all the faculties and all other viewers who are right now with us on our webinar. Over to you, Urvashi ma'am.
Thank you so much, ma'am, for your very precise introduction of what we are going to have in our today's webinar. Let me introduce our today's guest first before starting with the webinar. Today we have with us Dr. Rohit Moonka, Senior Assistant Professor, Campus Law Center, Delhi University. Sir has around 12 years of industry and academic experience and have been associated with universities like Institute of Law, Nirma University, Gujarat National Law University, to name a few, prior to joining Campus Law Center, Delhi University. Sir has also served as editors for various university journals as his service as assistant professor. Current interest areas and research areas for Sir include intellectual property law, arbitration, professional ethics, etc. Sir was also selected at City of Hague Scholarship by Hague Academy of International Law, Hague, Netherlands in 2017 session for private international law. Sir, we are privileged to have you today for this webinar and now I request you to deliver your expert session.
Thank you, Vidhi ma'am. Thank you, Urvashi, for a very generous and kind introduction and the welcome, ma'am. So it is indeed a matter of great honor and privilege for me to address the students and the listeners on a very pertinent topic related to IP. First, my thanks to the organizers, my thanks to all those who are involved in, and especially Urvashi for contacting me. And Urvashi being my student, it is really heartening to see your students, going to places and remembering your teachers. So thank you all. So without taking much time, since the topic of the for our discussion today, Urvashi, can you have the PPT? The topic is bioprospecting, biopiracy, and protection of traditional knowledge, international and national perspective. Now, as I presume that you must be aware of different forms of IP, be it patent, be it copyright, be it trademark or design, etc. Most of the intellectual property rights are based on quid pro quo. That is the very fundamental of the grant of intellectual property rights. That is something for something. You give something to the society, to the public at large, and in return the state gives you a monopoly right by way of patent, by way of copyright, by way of trademark, by way of design, etc., etc. However, we have one form of intellectual property law, unlike the usual forms of IPR which I have just stated, where this principle of quid pro quo does not apply. This is something we are talking about traditional knowledge. And before I get into the technicalities of this aspect, just try to understand things from example. I'm not going to take you through very legal jargons or technicalities. I would like to make it as simple as possible because I understand most of the viewers are students, and let's make it as simple as possible so that the student can understand this topic, because generally these topics are less discussed when it comes to IPR, but these are very pertinent and important topic, and you would find how they are related with other branches of IPR, which I have just stated. So as far as traditional knowledge is concerned, we all are familiar with the medicinal properties of, let's say, turmeric, or we all are familiar with the medicinal properties uh, of ginger, garlic, or honey. Different kinds of properties are there. For example, honey, if you take honey for example, now honey can be used for different purposes. It is anti-inflammatory, it can be used for the treatment of cough, cold, and various other uses are there. But the point is how we got to know that honey has got multiple uses, how we got to know that turmeric has wound healing property, how we got to know that uh, uh, garlic has anti-inflammatory properties or anti-cancer properties. And this is not something the present science is telling. It is being used since time immemorial, for a very long time, from our, I would say, our forefathers. They have been aware of these properties. So the point is, somebody must have contributed to, somebody must have experimented with all these things to get to know that different medicine, different herbs, different plants, different, uh, uh, let's say, artistic work. We have traditional artistic work, folklore, different traditional way of songs, traditional way of music. All these things have evolved over a period of time. But the point is, they are not owned by an individual, and they are enjoyed by everybody. As an individual, I know the medicinal property of turmeric, whatever I have mentioned, turmeric, honey, or ginger, garlic, neem, tulsi, because this has been passed on to me from my parents, from my grandparents, and their grandparents must have passed on it to them. and nobody claims monopoly right over it. And yet it is something which has the potential to be protected under the ambit of intellectual property. Why I'm telling you, I'm going to the very basics of intellectual property, because intellectual property law says that anything which is creation of mind, anything which is creation of human intellect, must be protected, must be given some sort of safeguard, so that the creator could use it, could maybe commercial use it, or other way, so that the creator could be enriched out of his contribution to the society. Unlike the notion of intellectual property law or the protection of modern intellectual property law, traditional knowledge is just opposite to this notion of intellectual property law protection. Because as I mentioned, here the knowledge is with most of us, but nobody can claim monopoly right over it. So it's a kind of a community right. It is a kind of a knowledge which has been shared from generation to generation, and nobody claims monopoly right over it. So far, so good, right? Now, the problem comes when somebody from the society or from the community or from some other country tries to monopolize this traditional knowledge, or this knowledge which I have just mentioned. Somebody tries to claim as it is their knowledge. There comes the problem. So there comes the issue of bioprospecting and biopiracy. So we would be proceeding in this direction. But now let's come to some formal introduction of the topic and the formal definition, so that we go in a structured manner. So on the slide, you can see the World Intellectual Property Organization. Though as such, there is no official definition of the term traditional knowledge, which we also call as TK. But WIPO has given, I'm sure you must be aware of World Intellectual Property Organization, which is a specialized body of United Nations based in Geneva. So they have come up with a definition of traditional knowledge. And what it says, that traditional knowledge is the knowledge, know-how, skills, and practices that are developed, sustained, and passed on from generation to generation within a community, often forming part of its culture or spiritual identity. You see, this is a very broad term. Traditional knowledge is not just about the medicinal knowledge, traditional medicinal knowledge. It could be traditional ecological knowledge. It could be traditional cultural knowledge, which includes folklore, music, dance, painting, drawing, the traditional way of doing it. And of course, the traditional medicinal knowledge also. So it is a very broad term, but as you see from the definition, that that kind of a knowledge or such practices, such skills, which are developed, sustained, and passed on from generation to generation. So it presupposes that traditional knowledge is not something which has come out of blue of its own. People have made enormous effort. People have made lots of experiments with whatever was available in nature to develop, to get new uses of the products. As I mentioned, nobody told us, nobody came in our dream to tell us that tulsi has got multiple medicinal properties. It is only because of human ingenuity. It is only because our forefathers are, the our earlier generations, they must have experimented. And it is not something which is over. It is a constant process. We are also experimenting with it, and we are also coming up with new knowledge about the existing such uh, products. So it is something which is developed, which is sustained. Whatever has been, whatever knowledge which has been evolved, it is sustained, and it is passed on from generation to generation. Generally, it is not documented as such. It is mostly transmitted orally within a community, and it could be part of the culture or the spiritual identity of the community, or the a particular set of people, or a particular tribe, or a particular sect, whatever you call it. So this is something which evolves over a period of time, which is sustained within that particular community, and it is passed on from generation to generation within the community. This is as per the WIPO's definition. Now, on the other hand, if you see Convention of Biological Diversity, I'm sure you all must have studied about CBD, the Earth Summit in your environment law paper. And this is also connected with the topic of traditional knowledge, because CBD was one of the first international instrument which has provided for its member countries to have adequate protection, to have measures for the protection of traditional knowledge. And under Article 8G of the CBT, it provides that traditional knowledge as knowledge, innovation, and practices of indigenous and local communities embodying traditional lifestyle relevant for the conservation and sustainable use of biological diversity. So again, because convention CBD was primarily for the international instrument for the safeguard of biological diversity, and traditional knowledge is a very important facet of biological diversity, because we are talking about traditional medicinal plant, traditional ecological knowledge, all are major constituents of uh, the biological diversity. So as per CBD's Article 8J, it says that TK as knowledge, innovation, and practices of the indigenous and local communities, which embodies their traditional lifestyle for the conservation and sustainable use of biological diversity. Both. It has dual purposes: conservation of biological diversity and sustainable use of biological diversity. You know, if we as a human being, we have to conserve the biological diversity, we also need to have sustainable use, because only conservation would not yield any result. We need to use it in a sustainable manner. So that has been provided under Article 8G of CBD with regard to traditional knowledge. Yes, can we move to the next slide? Right. This is just to, you know, just to explain you further what I have stated earlier. As you can see in the picture, that this tree of traditional knowledge, which consists of whether it is medicinal, agriculture, and ecological knowledge, it consists of music, dance, stories, poetries. You know, we have tribal forms of dance, tribal forms of music. You go to places like Jharkhand, you go to places like Orissa, they have their own, the tribes have their own style of own pattern of own designs of wall painting. So these are traditional paintings, traditional uh, forms of music. Then you have spiritual expressions. You have handicraft, which are of course traditional in nature. So if you see the upper part of this diagram, that is the tree, and the lower part of this diagram, that is the roots are, they are transmitted orally across generation. They are collective responsibility and ownership. As I mentioned earlier, in case of traditional knowledge, it's a collective ownership, and nobody can claim monopoly right over it. It is known by everybody, it is owned by everybody, and nobody claims individual rights over it. Unlike other forms of intellectual property law, whether it is patent or copyright, which is generally owned by individuals, traditional knowledge is not. It is collective ownership, but nobody claims monopoly right over it. And last but not the least, it is a constantly evolving. It is not something which has become stagnant. It is constantly evolving. Whatever knowledge which has been passed on from generation to generation, that is not something which has the evolution has not stopped. The previous generation, current generation, and the coming generation, all are also working on it to evolve it. So that is something, it's a constant process. It is not something that we have got something from our ancestors or from our community leaders, and that is the only thing, and this is not going to evolve further. That is a wrong notion. It is a constantly evolving process. Yes, can we move to the next slide? Now, a little bit more detail about it, because you might be wondering why the term traditional and knowledge. What is traditional and knowledge in this traditional knowledge. So just to dissect it further, if you see the term traditional in traditional knowledge, what it means that such knowledge which has been accumulated by any community or any society, any sect in the course of long experience in a particular place or ecosystem. So this is these two terms which have come together, traditional knowledge, out of which the by and large the term tradition includes such knowledge which has been accumulated by any particular kind of community, any particular kind of society, any particular kind of a sect, or any particular kind of a tribes during the course of a long experience. It is not something which has been created, which has been accumulated just in few years. Certainly it requires a long experience to get to know the different kind of practices, different kind of properties. For example, another example I would like to take you, not only just medicinal plants, we have traditional ways of doing cultivation, because this is also a knowledge which the people have gained through their experience, through their experiments, that at which uh, kind of a season, at which kind of a climatic condition, which crop should be shown, which would be give a better result, etc. This all have evolved over a period of time. As far as knowledge is concerned, in the traditional knowledge, it includes, as I mentioned earlier, it could be spiritual experiences, it could be philosophies, it could be the knowledge of technologies, it could be subsistence activities of the indigenous communities whose lifestyle is strongly influenced by their own tradition. So this is something, if you just go further, traditional knowledge as a term which has come together from the tradition and the knowledge, both which are evolved and practiced by the communities, by a particular sect, by a particular indigenous community, and whose lifestyle is very much influenced by their own tradition. Whatever they have evolved, it has contributed, it has furthered their lifestyle, their way of living. Right. Now, next slide. So, just to sum up about uh, the key aspect of traditional knowledge, or the key aspect of the definition of traditional knowledge, 3 points I would like to state. Three points have been stated over here: that it is held collectively. Nobody claims, no individual can claim monopoly right over it, and it is something which is owned by the whole community or collective ownership. Secondly, that it is very often not documented. Most of the traditional knowledge are not documented. Generally, they are not documented, and they are generally transmitted orally from generation to generation. In fact, amongst the community also, you might be aware, I'm sure you must have come across many such example where people are aware of various, let's say, medicinal property of particular herbs for the cure of particular disease, but they will not share which herb or how they have acquired that particular herb, which plant or which part of the plant, because that they want to keep it secret, and they just want to pass on to their own uh, uh, generation, etc., so that it does not go out in public and it is not misappropriated. So the fact remains that most of the traditional knowledge, they are not generally not documented, and they are transmitted from generation to generation by, generally orally it has been transmitted. हम कहते हैं ना कि दादी नानी से हम सुनते चले आ रहे हैं, हमें किसी ने नहीं बताया, nobody told us about the medicinal properties of turmeric, ginger, garlic, honey, tulsi. We got this from our parents or our grandparents, and उनको उनके grandparents ने बताया होगा. So this is generally transmitted uh, orally from generation to generation. And last but not the least point, that it is in the state of constant evolution, responding to constant challenges and needs. The classic example I would like to state over here is during the corona crisis, during the COVID-19 pandemic, you must have seen that how uh, the existing knowledge, the existing traditional knowledge was being used to find out medicines for the COVID-19 pandemic, for this disease. How the traditional knowledge was being applied, though there was some confusion also, but ultimately there were some using this traditional knowledge, using the existing knowledge which we had uh, about the various plants, various herbs, various entities, various pharmaceutical companies, various, I would say, including Patanjali, they were able to come up with uh, the for the treatment of COVID-19. That is a different issue whether it has got the proper approval internationally, etc., or not. But it has shown good result, and it shows that it is in a constant, evolution process, because they use the existing traditional knowledge and they experimented with it. They because of the current challenges and need, and they were able to come up with new responses. So it's a constantly evolution in the evolution process. So the last point I would like to state over here with regard to the definition of traditional knowledge, that the way it has been acquired and used, that is the reason why it is called as traditional knowledge, and not because of its antiquity, or not because it is just old knowledge. It is called traditional knowledge. ऐसा नहीं है. It has, the way it has been acquired and the way it has been used is the primary reason to call it traditional knowledge. So this is primarily with regard to the definitional aspect of traditional knowledge. Now we are moving in the next slide about the challenges which has been posed due to the uh, changing circumstances, due to the commercialization, due to the vested interest of commercial entities, how they are posing threat to traditional knowledge. And we have plenty of examples of this already. So I would like to move to the next slide after this. Yes. So now we have two facets of traditional knowledge, and because of these two facets, uh, there have been lots of hue and cry for the protection of traditional knowledge, even though the fact remains that traditional knowledge does not fit in the usual notion of intellectual property protection, because of the fact it is owned by everybody, it is a community right, and it is already in public domain. So it does not fit in the traditional, in the conventional notion of IP. Nevertheless, uh, these two terms, bioprospecting and biopiracy, first of all, we will understand them. We will see it through some illustrations and example, and how they have posed challenges, threat, or opportunity for the exploration and furtherance of traditional knowledge. So, as far as bioprospecting is concerned, you can see the definition of bioprospecting. It's a kind of a systematic and organized search for useful products which are derived from bioresources, which can include plants, microorganisms, animals, etc., and that can be developed further for commercialization and overall benefit of the society. Now, just try to understand that le- there are there are huge resources, there are huge natural resources or medicinal resources available in the wild, but without any kind of a hint, without any kind of a clue, it becomes extremely difficult for a scientist, for a researcher, to find out a particular herb or a particular plant out of the wild. So if you have certain knowledge, if you have certain hint that a plant with this much or this kind of a character is available in this particular forest, or this wild, this national park, it would make your things easier, it would make your job easier. So through bioprospecting, the scientists, the researchers, they indulge into a systematic and organized search for useful products which are derived basically from bioresources, because the term bio has been used. They are looking for such bioresources which could be plant, which could be microorganism, which could be animal, etc., and that can be further developed. What happens, let's say, uh, if the scientists got to know that a particular plant which is found in the forest of Western Ghats in Kerala has got uh, you know uh, anti-inflammatory and stress uh, uh, anti-stress properties. So if the scientists get to know about such properties, if they get to know about such properties of a plant which is found in the Western Ghats of Kerala, they can they can take that plant to their lab. They can do further research, modern scientific research on that, and whereby they can isolate the active compound, active proponent out of that plant, and then they can come up with a scientific modern medicine. So in a way, this is a bioprospecting is a proper, systematic, organized, ethical, legal way. I would say this is the legal way of exploring traditional knowledge related to bioresources, and then to evolve it, then to develop it further for commercialization and ultimate overall benefit of the society. And while doing so, let's say I'm going to discuss a case study on bioprospecting after this. You will see that how through bioprospecting the scientist got to know the medicinal property of a plant, and after developing the product, the scientific modern product, how it was when it was commercialized, how the benefit was shared with the community from whom the knowledge was shared, the traditional knowledge was acquired. So this is something bioprospecting is good. In fact, if you see the definition of CBD 8J, Article 8J, in fact encourages sustainable use of the biodiversity of the biological resources. So in fact it is very much in line with it is very much in tune with the international conventions also, because ultimately whatever resources, bioresources we have, biodiversity we have, it is ultimately for public good, but it has to be used in a sustainable manner. It should not be used in a way whereby it is misappropriated, it is misused, or it is being claimed by an individual at the cost of the entire society. Now, moving to the next slide, which is biopiracy. Now, this is the problem. The term piracy, I am sure you must be aware of the term piracy or pirates. So, when it comes to biopiracy, it is basically illegal appropriation, or you can say it misappropriation of bioresources, which includes plant, microorganism, and animal, and it could also include traditional cultural knowledge which accompanies it. So basically, what pirates they do, they steal, somebody else's goods, somebody else's ship, vessel, which is going on the high sea, right? Similarly, in case of biopiracy, the 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 biopirates, if I could call them, they basically misappropriate the traditional knowledge which are related to bioresources, as I pointed out, plant, animals, microorganism, or traditional cultural knowledge, and they claim it as if it is their own knowledge. They find it out, they develop a product, they make a scientific modern product out of it, and they commercialize it without any acknowledgement, without sharing of any kind of revenue, without sharing of any kind of license fee with the community, or with the people from whom they have acquired this knowledge. So it's kind of a discrediting, disowning to the traditional knowledge holder, and claiming that this knowledge belongs to me, this is my creation. That is the problem. That is due to biopiracy. There are so much hue and cry for the protection of traditional knowledge, and we have plenty of such example in the recent past, for past 20-25 years. You might be aware, and I am coming to that particular point only because as I mentioned earlier, my focus would be to understand the topic through examples only. So let's move to the next slide, uh, which talks about certain illustrations, and these are not illustrations, these are based on the cases which has occurred in last 20-25 years with regard to traditional knowledge. Now I have taken three such case studies. One, the Kani tribe case study, and which is regarding Jivani drug. The second is the turmeric patent, which was granted in US and subsequently it was revoked. And the third is the case of neem patent and the subsequent revocation, which was basically granted in European Union. So coming to the first case study of Kani tribe, and this is from Kerala, from as I was pointing out about the Western Ghats. So way back in 1987, a group of scientists from the uh, Tropical Garden Research Institute based in Trivandrum, TGBRI, they went for the exploration of the Western Ghats, uh, which is in Kerala only. And while they went to the Western Ghat, they took help of a nomadic tribe, Kani tribe, who were basically a nomadic tribe, but they are based in, they no, they keep on moving around the Western Ghats only. So because they are based in the Western Ghats only, in and around Western Ghats, these scientists thought of taking help of the Kani tribe to guide them while they're exploring the Western Ghats. So as a part of the exploration, when they went to the jungle, to the Western Ghats, they were very exhausted after a few hours of their exploration. After a few hours of trekking, they got exhausted. But they were very surprised that these tribals, few of them, 4 or 5 of them who were accompanying them, who were as a guide, they were quite energetic and quite like as if they are not at all tired. And they closely observed that these Kani tribes, they are munching some berries in between, which are found in that Western Ghats. So out of curiosity, they ask, what is this berries you are munching? Why you are not feeling fatigue or tired? Initially, they were reluctant to share the information about this because they have a practice. Kani tribe have a particular entity called Palathi, who is the possessor of this traditional knowledge about medicinal plants or herbs. And he is the only one who is permitted to transfer it to somebody else. So initially, these tribe, the other people, the Kani tribes people, were not willing to share this knowledge. But after great persuasion and insistence by the scientist from TGBRI, they shared that they are munching a particular berries from a plant which is called as Arogya Pacha, which is found in the Western Ghats, and that is giving them instant energy, which they keeps on munching. They keep on munching whenever they feel tired and fatigued. So the scientists also tried it, and they also felt the same. So now what they did, they brought those the entire plant, some of the samples to their lab in Trivandrum, and then they did scientific research in the modern laboratories. And after doing the research, they found out many properties of this plant Arogya Pacha, and they found that it has uh, anti-inflammatory properties, stress, anti-stress property. It's a kind of rejuvenating properties. So it has a huge commercial uh, potential, which they found, and they were able to segregate the active component, the active chemical component out of the plant. And out of their study, they found that instead of the fruit, the active components are better found in the leaves of Arogya Pacha. So you see how they got this knowledge. The scientists would not have or would never have got this knowledge uh, unless and until this knowledge was shared by the Kani tribes with the scientists. Since the Kani tribe people have shared this knowledge, they told that this plant has got this property which is giving instant energy to them. They took this plant from the wild and did modern research on that. Now, this is a very classic example of bioprospecting, because what the scientists did, what the TGBRI, because that was a government institution based in Kerala, what they did when they were able to formulate uh, uh, medicines, modern medicine out of it, they licensed it to a pharmacy company, an Ayurvedic pharmacy company, who, for the purpose of commercialization and marketing. And in lieu of that, for while they shared this with the pharma company, whatever royalty they received, 50% of that royalty, whatever royalty which was received by TGBRI, 50% of that was to be shared with the Kani tribes. You see, this is the beauty of, and this all thing has happened when, in fact, CBD had not come into existence, or CBD was just being discussed at the international level, because this incident is of 1987, and TGBRI were able to come up with the scientific product and for the commercialization by the pharmacy later on by 94-95. So that was the time when CBD was at just formulated, and it was at a very nascent stage of evolution. And yet we have an example from India where the traditional knowledge has been legitimately acquired by the scientific community. They did further scientific research on that. They developed a product, scientific product, which is something, uh, something which is scientifically certified. And then they were able to commercialize it, of course, with the help of a pharma company. And the profit, whatever license they are able to generate out of it, they were willing to share 50% of this with the Kani tribes. Of course, for that, it was very difficult task for them, because Kani tribe was not a single unit. They were scattered all over the Western Ghats. So for that, they took help of certain NGOs, certain governmental agencies to identify all the members of the Kani tribes. And after doing that, they were able to share. They created a trust out of it, and through that trust, all the members, the beneficiaries were identified, and that 50% of the revenue which were shared by TGBRI was shared to the Kani tribes, all the members, all the uh, uh, families of Kani tribes, because they were the ultimate owners of this knowledge of Arogya Pacha, from which the Jivani drug has been evolved. So this is a very classic example of India, from India, and this is a very classic example when it comes to bioprospecting, because here the intention was not to misappropriate. Here the scientists have not claimed that this is their knowledge, or they are the one who have created this. They are giving due acknowledgement that they have acquired this knowledge from Kani tribes, and due to that fact, they are willing to share the revenue with them in a very fair and equitable manner. So this is one such instance. The second instance of biopiracy. Now we are coming to the instance of biopiracy, and I am sure some of you might be aware of turmeric patent and its subsequent revocation in United States. So this is again, this has got the element of certain Indian scientist, certain Indian scientist of Indian origin, based in USA. They were basically scientists in the University of Mississippi. Uh, this is the matter of 1995, where the United States Patent Office, they awarded patent on turmeric to the University of Mississippi Medicinal Center for the wound healing properties of turmeric. And that was something which was the invention was the inventors were the Indian scientists who are now based in USA. So they have this Indian connection already. Now what happened, the claim subject matter was in this particular invention was the use of turmeric powder and its administration, both oral as well as topical, for wound healing. ठीक है? And you all must be aware, I'm sure, that the wound healing properties of turmeric are well known to Indians and South Asians. ये कहते हैं ना कि हम this is something a dadi nani's medicine. Whenever we have a minor cut or a minor small wound, our grandparents or our parents would suggest कि you take a little bit of turmeric along with milk, and it will be cured in a day or two. So this is something which is already known. But this is known, of course, this is not known out of blue. This is part of our traditional knowledge, which has been passed on from generation to generation. But the problem came when an individual, when the University of Mississippi Medicinal Center, the scientist of the University of Mississippi Medicinal Center. They filed patent application for that, and unfortunately, the patent was granted, despite the fact that it is already in public domain. I'm sure you must have studied in patent that while patent is granted, there is a search we call prior art search. But the prior art search is done generally based on what is documented, what is a published document, or in a way which is already documented. But unfortunately, as I mentioned earlier, the traditional knowledge is something, especially at that point in time in 1995, it was mostly undocumented. There was very few traditional knowledge which was documented. So that is the reason why the patent application for the turmeric powder for wound healing properties by University of Mississippi, it passed through the test of novelty and the patent was granted. But subsequent to the grant of patent, the Indian Council for Scientific and Industrial Research, CSIR, you must be aware, it filed objection to the grant of the patent, and it provided documented evidence of the prior art related to turmeric to the USPTO. Uh, CSIR had to find out various documents, had to find out evidences, written evidences, that turmeric has wound healing properties, because oral evidence would not suffice, even though it is a well-known fact that the use of turmeric uh, uh, in every household in India since ages. But the insistence of USPTO was to find out published information on the use of turmeric powder uh, through oral as well as topical route for wound healing. And after doing extensive researches, 32 references were located in different languages, namely Sanskrit, Urdu, Hindi, uh, and in fact some scientific literature was also published about the uh, medicinal properties of turmeric. So all these were presented to USPTO, and ultimately USPTO was satisfied that the medicinal property, the wound healing property of turmeric is already in public domain. It was already known, and there are sufficient literature, sufficient material, including scientific literature, are published prior to the filing of the patent with regard to the wound healing properties of turmeric. And based on that, they revoked the patent which was granted with regard to the wound healing properties of turmeric. So this is a classic case of biopiracy, I would say. By doing so, University of Mississippi, uh, even though they acquired patent, but they acquired patent based on a invention which is already, the knowledge of that invention was already in public domain. And as you know, patents cannot be granted unless it satisfies the three criteria: patent, the novelty, utility, and non-obviousness. And the first and foremost criteria is novelty, that the invention must be new. It should not be part of the state of the art. It should not be in the public domain prior to filing of the patent application. So unfortunately, the patent specification of turmeric patent did not satisfy the criteria, but the practice, the procedure in USPTO was that they would not look for undocumented, something which is orally available. They would only look for such published material which are well within the jurisdiction of USPTO, and that too which are published material. So that was the issue in the turmeric patent. Similarly, in case of neem patent, uh, this is also a similar kind of an instance, but this was not in USA. This happened in European Union. Now, in case of the neem patent, uh, as again, before I get into this, you all must be familiar with the medicinal properties of neem. Neem has got multiple properties. One of the property of neem is antifungal properties. You must have come across your parents, grandparents using the leaves of neem, for the putting some of the dried neem leaves in the food grains. I'm talking about 20, 30 years back, when we did not have the modern gadgets for the preservation and storing food grains, etc. So neem had this antifungal properties And this feature of neem, this knowledge about the antifungal properties of neem is known to us, is known by most of us, most of Indians and South Asians for a very long time. Now, what happened? The Department of Agriculture of US, along with W.R. Grace, uh, they filed a patent application before the European Patent Office with regard to the antifungal properties of neem. So basically, that patent was a method of controlling the fungi on the plants, which was comprising of contracting the fungi with a neem oil formulation. So after this application was filed, this patent application was specification was filed before the USPTO, and of course there were a lot of hue and cries. Certain Indian NGOs, along with some international NGOs, they protested, but unfortunately, uh, this was granted. The patent was granted, but after the grant of the patent, again, as you know, post grant opposition can be filed. So these NGOs, certain Indian NGOs, along with their international partners, they led a huge protest, and they filed their opposition against the grant of patent for the grant of this patent for the antifungal properties of neem. And in fact, they were able to produce various documents, again from the ancient text, that neem has got multiple medicinal properties, including treating the disease of leprosy to diabetes, skin disorder, ulcer, etc. And this has been used since time immemorial. They submitted evidence of ancient Indian Ayurvedic text that has described the hydrophobic extract of neem seeds, which were known and used for centuries in India, both in curing dermatological disease, both in human as well as protecting agricultural plant from fungal infection. So this is already part of the Ayurvedic text, Indian Ayurvedic text, and the EPO, the European Patent Office, found out that this application for which the patent was granted, it lacked novelty, it lacked inventive step, and it was possibly form a prior relevant prior art, because it is already in public domain. And once the knowledge about any invention is in public domain, patent cannot be granted. So they were bound to revoke the patent. So the patent which was granted on neem, again, this is a classic example of biopiracy, because the knowledge which is owned by the community, which is owned by millions and billions of people, how an individual can claim monopoly right over it by way of getting a patent out of it. However, after the revocation of this patent, appeal was filed before the European Patent Office, but the appeal was also subsequently dismissed. So ultimately, the patent which was granted on neem, the invention related to neem, was revoked, and that was a very it is something, a big victory for the Indian entities, Indian NGOs, and the Indian people, because otherwise, giving monopoly right over something which is already known to us, so in such a way, we won't be allowed to use neem for its antifungal property without taking permission or without paying royalty or license to the patentee in such case. And that is something which cannot be the situation, because as you know that knowledge which is already in public domain cannot be subjected to grant of patent. So these are the three classic example. Kani tribes case is a classic example as far as bioprospecting is concerned. Turmeric and neem case are classic example of the instance of biopiracy is concerned, because here the individuals, they are trying to steal this, they are trying to misappropriate this knowledge and claiming it as if it is their own, which should not be the case. And that has led to a lot of hue and cry for the protection of traditional knowledge, uh, how to protect it, how to discourage or how to stop biopiracy, especially. And for that, a lot of hue and cry has taken place after all these incidents have happened. Now, let me tell you, there is no such international convention or treaty, particularly on the safeguarding of traditional knowledge. there is not a specified or a specific international convention or instrument for the safeguarding or on traditional knowledge. That is very unfortunate. However, there are other international conventions, as I mentioned about CBD, and some other international conventions which provides for protection or safeguard of traditional knowledge, but that is in piecemeal. So what now we are going to look, what are the international initiatives so far, what has taken place, and what kind of protection which could be accorded to traditional knowledge or for the safeguarding of traditional knowledge. And lastly, we are going to look into what initiative India has taken with regard to uh, safeguarding traditional knowledge. So these are the three segments. Now we are moving towards the safeguarding of traditional knowledge. Uh, can we move the slide? Yes, international initiative. So as you can see, there are, as I mentioned earlier, there are international initiatives, but they are not directly or not particularly on traditional knowledge. However, you can take example of CBD. CBD was primarily for the protection of biological diversity, but under CBD and its Nagoya Protocol 2010, they introduced, in fact, the recognition and protection of TK at international level for the first time. And as I mentioned earlier, Article 8G of CBD, which requires party to respect and maintain traditional knowledge or such knowledge which are held by indigenous community, promote broader application of traditional knowledge based on fair and equitable sharing. So if you go deep into this definition, you would find three facets, three aspects of this. First and foremost, Article 8J of CBD, it requires the members country to respect and maintain traditional knowledge. So for the conservation or preservation of traditional knowledge, you respect it, you maintain it, which are held by the traditional communities, indigenous community. Second is promote broader application of traditional knowledge. So in a way, the second aspect of this definition promotes bioprospecting. You promote broader application of TK because the knowledge, if this knowledge is not going to be utilized, it is not going to benefit the society at large. It might be just held with a particular community or a particular tribe or a particular sect of the society, and it may not be useful for the larger uh, public at large worldwide. So in a way, it should promote broader application of traditional knowledge. But the third facet says fair and equitable benefit sharing. While bioprospecting is allowed, but any such bioprospecting which leads to commercialization of that traditional knowledge should culminate in fair and equitable sharing, benefit sharing out of that, as we have seen in the case of Kani tribe, where the TGBRI, they shared 50% of their license fee with the Kani tribes. So that would be a classic example of fair and equitable benefit sharing, right? So this is something as a part of CBD, and of course Nagoya Protocol is a facet of CBD. They provide for CBD provides for it, as you can see for Article 8J in this regard. Next slide, please. The next international treaty for which provides for the protection of traditional knowledge or which provides for safeguarding traditional knowledge, it is ITPGR-FA, International Treaty on Plant Genetic Resources for Food and Agriculture. The Food and Agriculture Organization, which is another body under the United Nations, they had come up with a treaty called ITPGR, uh, and especially with regard to food and agriculture, dealing with plant genetic resources for food and agriculture. Under Part 3 of this ITPGR, it recognizes the enormous contribution of the local and indigenous communities and farmers of all regions of the world to the conservation and development of plant genetic resources. Now, please note that the whatever plant genetic resources we have, whatever crops we have currently, forget about the hybrid crops or the high-tech crops which are developed through modern biotechnology, the existing, the wild races, these are something we got this because of the conservation and development of plant genetic resources by the local communities, by the local farmers. Otherwise, these are the resources which are helping in developing the modern hybrid varieties of plant. So ITPGR, on the first hand, it recognizes the huge contribution, enormous contribution, which the local and the indigenous community and the local farmers, indigenous farmers of all the regions of the world, not specific to a country, all the traditional and indigenous communities and farmers who have contributed to the conservation and development of plant genetic resources. Now, what it further provides, ITPGR, that the members countries, they are obligated to take measure to protect and promote farmers' right, including protection of traditional knowledge relevant to plant genetic resources for food and agriculture. Since there is this treaty is not, again, it was not on traditional knowledge per se, but it has got the element of traditional knowledge because it was on plant genetic resources. And as I mentioned earlier, traditional knowledge related to traditional ecological knowledge, or traditional knowledge related to plants, medicine, all sorts of plants are a very important facet of traditional knowledge. So by virtue of ITPGR, members country were obligated to take adequate measure for the protection and promotion of farmers' right, including protection of traditional knowledge which are relevant for plant genetic resources for food and agriculture. So this was another important development, I would say. But again, this is not directly on traditional knowledge, but it has got a facet of traditional knowledge in it. Next slide, please. Right. Now, this is the ILO has also got some element of safeguarding traditional knowledge. Convention 169 of ILO, International Labour Organization, it recognizes and protects the social, cultural, religious, and spiritual values and practices of indigenous and tribal people. So, in fact, this has come prior to CBD. So in a way, you can say for the first time, the contribution of indigenous and tribal people were recognized in any international instrument. It was ILO's Convention 169. And if you go further, Article 4 of ILO Convention says, which provides for special measures which are to be adopted as appropriate for safeguarding the persons, institutions, property, labor, culture, and environment of the people concerned. And in fact, Article 8 further states the need for the recognition of customary law system. So, in a way, this again, ILO, International Labour Organization, through its Convention 169, it recognizes and obligates the members, its member, to protect the social, cultural, spiritual values and practices of the indigenous and traditional communities, traditional people, tribal people, because that is something which cannot be ignored, which cannot be let go. And please note, this was the very first, even prior to CBD, it came into being. Yes. Next slide, please. Right. Now we are coming, because these are the major international, I would say, initiative. Unfortunately, there is no specific treaty or convention on the safeguarding of traditional knowledge. World Intellectual Property Organization is having intergovernmental committee on traditional knowledge, and that IGC is working for past more than 22 23 years, but unfortunately it is not able to come out with a final draft of an international convention or a treaty for safeguarding traditional knowledge. And there are various vested interests. I can also give a little bit of insight on that, because as you know that most of the traditional knowledge, or I would say a large chunk of traditional knowledge, are based in developing countries, whereas the developed countries, they are rich in technologies, modern technology, advanced technology. So most of the developed countries, they have a vested interest. I would not like to pinpoint any country over here. I'm just dividing this, north south divide, or developed country or developing countries uh, conflict, so to speak. So developed countries, on one hand, they are rich in technology, but mostly poor in traditional knowledge or biodiversity. On the other hand, you have developing countries who are poor in technology but are rich in traditional knowledge and biodiversity. So there is a vested interest of course, you can understand what I am trying to convey, that developed countries are not very keen to have a proper instrument on traditional knowledge, an international convention on traditional knowledge, because once that is in place, all the members would be obligated to have adequate protection for the safeguarding of traditional knowledge, whether you are a developed country or a developing country or a least developed country, and that might be detrimental for the interest of particularly of the developed country. So again, without going further into that, you can keep track of the WIPO IGC on traditional knowledge. You can search on that what is happening over there, and hopefully that would come up with a specific instrument, international instrument on the safeguarding of traditional knowledge in near future. Now, what we need to understand after this, that due to the nature of traditional knowledge, somewhere it does not fit in the existing mechanism of IPR, whether it is patent, whether it is copyright, whether it is design law, whether it is GI, whether it is trademark. It nowhere fit into any of these instruments, because patent cannot be granted over a invention based on traditional knowledge, because it is already in public domain and it would not satisfy the requirement of novelty. Similarly, copyright cannot be granted because copyright requires fixation, and most of the traditional knowledge are not in a fixed form. They are orally transmitted, as I mentioned earlier, or they are not documented, so to speak. Similarly, for design, which is something owned by individual, and whereas traditional knowledge is owned by community. Similarly, for any form of IP would not fit into the unique requirements of traditional knowledge, and that is the reason why there are proponents who are talking about sui generis form of protection for traditional knowledge. Nevertheless, in this slide, which is in front of you, you can see there are two categories given: defensive or positive protection. So before going into what could be the ways, what are the ways of safeguarding or protecting traditional knowledge, mostly it has been divided into two. The first is defensive. Now, what do you mean by defensive protection of traditional knowledge? It said this is a kind of a set of strategies which ensure that the third parties do not gain illegitimate or unfounded intellectual property rights over the traditional knowledge. So, the strategy is to see that any unscrupulous person, a third person, a biopirate, he or she does not get any kind of unfounded IP right over the traditional knowledge, mostly by way of patent. So this is a kind of a defensive mechanism, and the classic example is, just if you have understood the illustration of neem or turmeric patent, because the patent was granted because there was no such published document at the time of grant of patent. So, had there been published material available and linked to the USPTO, probably they would not have granted the patent itself, and there was no question of subsequent revocation. So, what has been done after this? There is a very innovative step taken by Indian government. That is, they have established an institution called TKDL. I will discuss it in detail after this. That is a defensive mechanism. Through TKDL, the full form of TKDL is Traditional Knowledge Digital Library. Through TKDL, the CSIR, which is a Indian government's apex body when it comes to agricultural research, they have documented, in a way they have uh, all the traditional knowledge which are available by way of Ayurveda, by way of Unani, Siddha, ways of treatment, which were found in different literature in Sanskrit, in Urdu, in Farsi, which are available, were translated in 5 international languages and uploaded, on the internet, on the website, and they were linked to various patent agencies across the globe. So now the traditional knowledge, uh, which was otherwise not documented, has been documented, has been digitalized, and linked to the patent offices. So any such invention which has been now, which will be filed for the grant of traditional, for the grant of patent, which has any link with any of these traditional knowledge which are part of Ayurveda, Unani, Siddha way of treatment, would immediately be refused, because that will not satisfy the requirement of novelty. It is already in public domain, and therefore it is out of, there is no question of grant of patent. So this is a defensive mechanism for protecting traditional knowledge. But through defensive protection, through defensive mechanism, there is no positive gain to the community. Like, the possessor of traditional knowledge are not going to gain out of it, they are not going to gain anything out of it, no monetary benefit, etc. And therefore you need to have positive protection for whatever has been stated here, the ability to deny or authorize access and use. Once you have positive protection, for example, let's say the if there is a patent granted, or if, let's say, if a copyright given to an author, so the once the copyright is given, once the copyright is granted, the author has got bundles of right. We call it bundle of right. And that right includes, allowing somebody or denying somebody to use that particular copyrighted work, right? So similarly, once the positive protection with regard to traditional knowledge is provided, that the traditional knowledge holder would have the ability to deny or authorize the access and use of that particular traditional knowledge. Secondly, the prevention of misappropriation. They would be able in a position to prevent the misappropriation, because they would make a condition of prior informed consent, including the conditions of use. Let's say somebody, some scientific community, or any company, or pharmaceutical company, wants to explore certain medicinal plants which are found in, let's say, uh, uh, in the run of Kutch. So for that, they need to take due permission from the community or the tribes who are the owner, who have got this right over this traditional knowledge. And the community can ask the scientist or the researchers to have a prior informed consent, PIC, that there is a prior agreement between them under what conditions they are going to use these resources. And what if they come up with a new material, what if they come up with a scientific product out of the research, how they are going to share the benefit sharing. The third point is benefit sharing on mutually agreed term, right? So how that is going to be shared, everything could be specified. If the community, if the indigenous community or the tribes or the sect have got positive protection over the traditional knowledge. So broadly speaking, traditional knowledge could be protected through these two mechanisms. One could be defensive, another could be positive protection. Now coming to what India has done. uh, Next slide, please. Right. So now, as you can see in this slide, uh, what India has done, again, there is no specific law or statute for the safeguard of traditional knowledge. But in compliance to various international conventions and treaties, and some of the experiences, bitter experiences, which India had because of the biopiracy which it has faced, and the litigation it has faced due to biopiracy of its traditional knowledge, India has either enacted or formulated or amended certain laws, existing laws, whereby trying to safeguard, both trying to give positive protection as well as what you say, defensive protection for traditional knowledge. Now over here there are, I have jotted down which all acts are relevant for this purpose. But please note, not every act which are pointed out, which are jotted down here, has got specific provision for the safeguard of traditional knowledge. They are in piecemeal. Again, they are scattered and haywire. So the first and foremost law, as far as India is concerned, uh, is Biological Diversity Act 2002, which you know has been enacted in compliance to the CBD. So what CBD has provided, as I mentioned about Article 8J, then you have Article 15 of CBD, they have all talked about and provided for the conservation, preservation, sustainable use, and access and benefit sharing of traditional knowledge and indigenous knowledge related to biological diversity and biological resources. It has got adequate protection under the Biological Diversity Act 2002. You may refer to Section 19 of the Biological Diversity Act, as well as Section 21. What it says, uh, if you refer to that, Section 19, subclause 2 particularly is relevant for this purpose. Basically, Section 19 talks about approval by National Biodiversity Authority for undertaking certain activities. So whenever an individual or a scientific organization has to undertake certain activity, they have to take the prior approval of National Biodiversity Authority, which has been established under the Biodiversity Act. And the particularly I am referring to Section 19, subclause 1 and 2. What it says, subclause 1 says, any person referred to in subsection 2 of section 3 who intends to obtain any biological resources occurring in India or knowledge associated thereto for research or for commercial utilization or for biosurvey and bioutilization, or transfer the result of any research relating to biological resources occurring in or obtained from India shall make application in such form as the fees may be prescribed to the NBA. And particularly important is 19 subclause 2, that any person who intends to apply for a patent or any other form of IPR, whether in India or outside India, referred in subsection 1 of section 6 of Biological Diversity Act 2002, may make an application in such form and in such manner as may be prescribed to the and prescribed to the National Biodiversity Authority. So in a way, it has been made part of the Biological Diversity Act that any person who intends to apply for either patent or any form of IPR, either in India or outside India, with regard to the bioprospecting work it has carried out, has to make an application in the manner prescribed under the BD Act and its rules to the National Biodiversity Authority for the safeguarding the interest of the indigenous knowledge holder. Basically, this provision has been made in compliance to, I would say, the mandate of CBD, as you can see for yourself. Another provision of the Biological Diversity Act, Section 21, you may refer. Now, if you have, and I would suggest the students and the viewers, you can refer this section at your convenience. You can note it down right now. I'm referring it for your convenience. Section 21 of the Biological Diversity Act 2002. What it says, determination of equitable benefit sharing by a National Biodiversity Authority. It says that the NBA shall, while granting approvals under Section 19 or Section 20, ensure that the terms and conditions subject to which approval is granted secures equitable sharing of benefit arising out of the use of the associated biological resources, their byproducts, innovation, and practices associated with their use, and application and knowledge related thereto in accordance with mutually agreed terms and conditions between the persons applying for such approval, local body concerned, and benefit claimers. Here, the role of NBA while granting such approval under Section 19, which we just referred, is to ensure that the terms and conditions of such approval has adequate provision for securing equitable sharing of benefit arising out of the use of such uh, biological resources and their byproducts, such innovation and practices. And in this regard, the mutual terms and conditions would be subjected to the approval of the local bodies and the benefit claimers. So, in a way, NBA has been tasked under the mandate of CBD to ensure that there are adequate measures for access and benefit sharing. While you are allowing somebody, some entity, whether Indian or foreigner, to explore the biological resources, Indian biological resources, Indian traditional knowledge, if they are able to come out with any product for commercialization, that thing has to be shared, the commercial the outcome has to be shared in a fair and equitable manner, based on the mutually agreed terms and condition. But the thing is, there must be access and benefit sharing in a fair manner. So this you can see in the Biological Diversity Act, which was enacted in 2002. Similarly, you have the Patent Act. Now, Patent Act is not a new act; it is a old act, of course, which was there prior to. It is there since 1970, and prior to that also we have Patent Act. But after the bitter experiences India had, particularly with regard to the grant of uh, neem patent, turmeric patent. India has amended its Patent Act in the year 2002, and certain new provisions were added. One of the sections, I have referred to the sections, you may refer to these sections. One of the section is section 3P. Now, as you know, section 3 of the Patent Act talks about non-patentable invention. If you have, you must have referred it in your patent, the topic of patent. What section 3P says of the Patent Act, that an invention which in effect is traditional knowledge, or which is an aggregation or duplication of the known properties of traditionally known component or components, then it would be considered as non-patentable, because section 3 has given a whole list of such inventions which are non-patentable. If you see section 3 of the Patent Act 1970, and section 3P is the particularly relevant for this purpose, which makes a invention which is basically traditional knowledge, or which is an aggregation or duplication of the known properties of traditional knowledge or components. So let's say, there is if there is any minor uh, any such invention which has got the component of traditional knowledge, a minuscule changes, or very, such changes which a person skilled in the art can do, which would not satisfy the criteria of non-obviousness, would not qualify for the test of uh, uh, patentability, and patent would not be granted over there. So in a way, any such invention which has got the element of traditional knowledge, some other provisions are also done, and that you can see under section 25 and section 64. uh, you can refer to this section, maybe right now or maybe after, at your convenience. So what section 25 of the Patent Act says, basically, uh, it's a we are not going to read the whole section over here. I'm just going to pinpoint both section 25 and 64. They provide the grounds for revocation of the patent application if it has got, like, the subsequently it has been derived that, uh, on various factors which are given under these sections, but we are primarily concerned about the traditional knowledge, and they have got, it has got, uh, being it has covered under these section, both section 25 as well as section 64, which is the section for the revocation of patent. uh, so that is there. Another feature, I would say, in fact, now there is a provision made under the patent rules, that if any invention has got any element of bioresources, then the applicant must state the origin of that bioresources and the all the details, so related to that. Otherwise, non-giving disclosure of such details would, give the right to the patent authority to outrightly reject such application. So again, these are the safeguards which are being made in the existing system by the Indian government to ensure that frivolous or such patents are not granted which are based on traditional knowledge, and that is something which would be allowing an individual to claim monopoly right over the community right. Then you have the PPVFRA, Protection of Plant Varieties and Farmers Right Act 2001. Uh, Again, this law was enacted in compliance to TRIPS agreement, because TRIPS agreement mandates that members country, by virtue of Article 27 clause 3, that members countries would have protection to plant varieties either by way of patent or by way of any sui generis form of protection, or a combination of both. So India, in compliance to that mandate, because India is a member to TRIPS agreement, has come up with a separate statute for the protection of plant varieties. So please note, plant varieties are not patentable in India. They are subjected to registration. They are subjected to protection under the Plant Varieties and Farmers Right Act. Now, under this act, because we are talking about traditional knowledge, we are not going to discuss about plant varieties and farmers' right. You may refer section 39 and section 41 particularly. These are the two sections which are relevant for this purpose. Section 39 talks about farmers' varieties. Now, as far as farmers' variety is concerned, if you see section 39, please note it down. You may refer it as per your convenience. Uh, just a second. So, if you see section 39, basically, section 39 talks about farmers' variety, and especially why it is relevant, though it has not directly any reference of traditional knowledge, but what it says that a farmer who has bred or developed a new variety shall be entitled for registration and other protection in a like manner as a breeder of variety under this act. So there are different kinds of varieties which are stated under the Plant Variety Protection Act. Uh, One of the variety is farmer's variety. So this is something which is allowing the farmer who has developed a new variety would also be entitled for registration of that particular variety under the Plant Variety Protection Act. Unfortunately, this instrument, which has got very innovative provisions, is not giving very good result because of the fact that most of the Indian farmers are marginal farmers. They are Most of them are small farmers. They are not institutional. We don't have institutional farming in India, unlike US or Europe or Canada, Australia. Are not very much aware of their legal rights. So in a way, even though, and especially, if you have to apply for registration of a farmer's variety also, there are technical requirements which are to be satisfied. So it is not by default. So that is something not yielding a very significant result. Another example, another provision you may look from the Plant Variety Act is section 41. Now what section 41 says, uh, section 41 of the Plant Variety Act states that uh, so basically it talks about the claim by or on behalf of the local community towards its contribution in developing a variety to the Plant Variety Authority. Under the Plant Variety Act, there is the Plant Variety Authority which has been established, just like under the BD Act, you have the National Biodiversity Authority or State Biodiversity Authority. So under section 41, if you refer section 41, which is titled as Rights of Communities, what it says that any person or group of person or any governmental or non-governmental organization may, on behalf of any village or local community in India, file in any center notified with the previous approval of central government, uh, any claim attributable to the contribution of the people of that village or local community, as the case may be, in the evolution of any variety for the purpose of staking a claim on behalf of such village or local community. So, in a way, by virtue of Section 41, I would say this is something a positive uh, safeguard for the communities to some extent with regard to any such plant varieties where the community or the village or the whether it is indigenous community or the tribes, whosoever from the village or from the particular sect, if they are claiming that any such claim attributable to the contribution of that particular people of that community or that sect or the village, if they are claiming any such attribution to the contribution of the people of the community in the evolution, in the development of a particular plant variety, then they can make this claim to the authority in this regard, the plant variety or authority in this regard, and the authority would look into this application, and if they find that a significant contribution made by these communities in the evolution of any such variety which is protected under the Plant Variety Act, then accordingly they will direct for the sharing of the benefit and sharing of the revenue with them by the one who has registered the variety under the Plant Variety Act. Another act you have, apart from the Plant Variety Protection and Farmers' Right Act, you have the Geographical Indication Act. Now, Geographical Indication Act has a very limited, I would say, it also to some extent covers or safeguards the traditional communities, but it has got a very limited application because it is confined to a particular geographical locality or a product, agricultural product, or a manufactured product coming out of a geographical locality, which has some unique properties because of the geographical condition prevailing in that place. So it might have a very limited application. Of course, after getting the GI tag, the commercial value of the product increases manifold, and that could be be beneficial for the communities who have got a GI tag in a way so that they earn more revenue out of it, which could be shared with them. But it has got a very limited application per se. Now, so these are the legislative measures we India has taken so far. Again, all are in piecemeal. There is no specific law, legislation, or statute on this point. Now, on the administrative side, I have already mentioned about TKDL, Traditional Knowledge Digital Library. So I'm not going to repeat that. Traditional Knowledge Digital Library is a defensive mechanism, which is an initiative and the brainchild of CSIR, especially after the bitter experience, I would say, of turmeric patent and the neem patent. They have translated and digitalized all the ancient knowledge, ancient text, ancient literature, especially related to medicine, from Ayurveda, Unani, Siddha way of treatment, and that was uploaded. The repository was made in this library, digital library, and this TKDL is linked to the prominent all the patent offices across the world now. So any such invention after the TKDL came into existence, prior art search would also consist of search on TKDL if that invention has got any element of traditional knowledge. And in such case, that particular patent office, because this is available on 5 different international languages, including Japanese, including Spanish, English, of course, and French, and the other one, the 5 languages which are the recognized international language by UN. This is something which is ensuring that no such patent is granted on an invention which is already in public domain based on traditional knowledge. So it is acting as a defensive mechanism, as I stated earlier. However, there are proponents who are critique of TKDL who are critiquing in a manner that they are suggesting that India has itself has given all its traditional knowledge, shared its traditional knowledge with world at large by itself, and that is something would open the floodgate of biopiracies. But the fact remains that the threat of not documenting, not digitalizing and documenting these information is much more higher than making it available to the public at large. Because as you know, as law student, uh, uh, as legal communities, that once the knowledge is in public domain, any invention based on such knowledge is not patentable. And even if the patent is granted, it can be subsequently revoked based on the fact that the knowledge was already in public domain and it would not satisfy the criteria of novelty. Similarly, I just missed out on this point. Under the Biological Diversity Act, there is under Section 41, there is a provision for community level databases. If you refer to Section 41 of the Biological Diversity Act, what it provides that the local communities, they are mandated to maintain uh, the maintain and documentize the biological diversity, including the preservation of habitats. So I just refer it for your convenience. What Section 41 subclause 1 only I'm going to refer. Every local body shall constitute a biodiversity management committee, which is often called as BMC, within its area for the purpose of promoting conservation, sustainable use, and documentation of biological diversity, including preservation of habitats, conservation of land races, folk varieties, and cultivars, domesticated stocks and breed of animal and microorganism, and chronicling of knowledge relating to biodiversity. So in a way, this has been one of the mandate for the biodiversity management committee, which is to be constituted at the micro level to documentize the biodiversity available in that particular locality, which includes whatever mentioned over here. So this is another way of documentization of the biological diversity, which includes conservation of land races, folk varieties, habitats, uh, domesticated stocks and breeds of animal, microorganism, etc. All are covered as a part of the documentation. And as you know, documentation has its own merits because that acts as a defensive tool against the grant of any monopoly right over it. So broadly speaking, these are the measures, both legislative and administrative measures, which India has taken place, which has taken place in India, and over a period of time. But again, I would say there is a dire need to have a specific, exclusive statute safeguarding or taking care of all aspects of the protection of traditional knowledge, which is unfortunately India is also waiting for an international instrument to come up first and then to have the law. Right. So next slide. So the concluding points. Now we are moving towards the conclusion of this. As you can see from the discussion so far, that traditional knowledge, of course, needs adequate protection from biopiracy and misappropriation. You can't let go this sea of knowledge, which has been evolved, sustained, and developed over a period of time and which has been passed on from generation to generation. It cannot be allowed to be misappropriated by some individuals, companies, or organizations and claiming it as their own without sharing a single penny of revenue with the actual knowledge holder. So that is something which is the first and foremost thing which needs to be done. And of course, traditional knowledge cannot be protected by domestic measures alone because of the fact that uh, you know there are threats of transboundary misappropriation. Let's say there are protection. If India comes up with a national law, exclusive law on traditional safeguarding traditional knowledge, of course that will help to a large extent. But let's say if a foreigner takes the Indian traditional knowledge, steal it, misappropriate it from India, and take it to his home country, which doesn't have a specific law on traditional knowledge. So in such a way, because and as you know, laws are territorial in nature. So Indian law would not apply to that foreigner once the foreigner is outside the country, outside the territorial jurisdiction of India. So in such case, that particular foreign national or foreign company would be in a position to misappropriate by some or other way. So that is the reason why there is a need to not only a domestic level, but there is a need for international level. So that is the third point is uh, the international legal instrument is a must, is a prerequisite to provide stronger protection to all forms of traditional knowledge, which is currently lacking because as we have seen it earlier, there are international instruments in piecemeal. They are not per se on traditional knowledge or safeguarding traditional knowledge. They are dealing with different branches or different aspects which might have some nexus with traditional knowledge. So there is a need for a specific exclusive international instrument, international treaty or convention. And I'm very sure that the WIPO's Intergovernmental Committee on Traditional Knowledge should come up with a international treaty or convention in near future, uh, leaving aside any vested interest whatsoever, or the interest of developing countries should be kept aside, because ultimately, uh, you know, it's not about the fight between developed and developing countries. It is, you are talking about the rights of the communities, you are talking about preservation of biodiversity, you are talking about safeguarding such knowledge which has been evolved, developed, and preserved since time immemorial. So that cannot be allowed to be misappropriated. That would be injustice to the knowledge holder, and of course, would be injustice to various other stakeholders. So that is something, there is a need of the hour to have an international instrument as at the earliest, so that the members could have also the respective IP laws, respective statutes, and that could provide adequate safeguard to the traditional knowledge. So with this, I stop here. I think we have covered all the aspect. Yes, if there are questions, I would be very happy to take up questions.
Yes, sir. We do have few questions, sir. So quickly we'll take up that. The
Yeah.
first question is that, sir, can you share your knowledge regarding status of genetically modified organisms under intellectual property law protection?
Sorry, could you repeat the question, Urvashi? I
Yes,
just
sir. Can you share your views regarding status of genetically modified organisms or GMOs under intellectual property law protection?
okay. See, genetically modified organisms are something, yes, because we are in an era of biotechnology, and using this biotechnology both in the field of agriculture, both in the field of genetically of human gene, or for that matter, animals, the GMOs, genetically modified organisms, are being created. You have the very famous case, I'm sure you must be aware of, the Diamond versus Chakravarti case, which was the first instance in US where genetically modified organism was granted patent, right? So yes, we are please know that genetically modified organisms are subjected to patent, because in such case they have to that satisfy the criteria of patentability. And of course, they should not be such which is already in public domain. So you can't simply take a microorganism which is already in public domain, if that is genetically modified and which has come up with a new utility, which has come up with a new purpose, and which is something non-obvious, then it would certainly get patent, as it was held in Diamond versus Chakravarti. I'm sure you must be aware of the case of Diamond versus Chakravarti from 1980. It was a case of from 1980 in United States, and that was the first case where the US Supreme Court had allowed the grant of patent over a genetically modified organism. And of course, since that time, the things have evolved, and even the courts have allowed in a way. So as far as microorganisms are concerned, yes, but you can't have patent, you can't have monopoly right over the human being or the animal per se, because we have seen the cases of like for example dolly sheep. So as an animal as a whole, you can't be allowed to take claim monopoly right over it. But as far as microorganism, genetically modified microorganism, subject to fulfillment of the test of patentability, yes.
So the next question is that as we have discussed, the traditional knowledge is not documented and passed from generation to generation. But if it would have been documented, whether the Indian IP laws would be ahead than Western countries?
Whether the Indian IP laws,
Yes, sir.
uh, I would say it's not question of being ahead from Western countries or not. The question is, had the traditional knowledge being documented, then certainly what has happened, for example, what the patent with regard to turmeric, the patent with regard to neem, which was granted, would not have been granted, because at the time of grant of these patent, the traditional knowledge related to these were not documented and they were not available to the respective patent offices. So had that been documented, the patent would not have been granted, and that would have, in a way, it's not question of being ahead from Western countries, but it's question of not your invention, and yet you are claiming monopoly right over it. So therefore, it was not just, and therefore that should not be allowed.
And so one last question is that do you think that the patent eligibility criteria, which is there in the 1970 Patent Act, needs to be changed or amended, looking at the new areas of patents?
I would say, see, the criteria for the grant of patent remains the same. But yes, depending upon the changing circumstances, depending upon the changing situations, there are certain changes, some additional requirements being added. For example, as I mentioned that nowadays, this has happened few years back, that any invention related to traditional knowledge, so the inventor has to give a disclosure about it, which was not the case prior to that. But the the criteria for the grant of patent remains the same. That is the novelty, utility, non-obviousness. The none test has to be is the basic parameter. But of course, there are amendments, there are changes by way of changes in the rules, etc., and amendment in the law. But the fundamental requirement criteria remains the same, which I think it is universally acceptable. It is not just in India; it is across the world. These three conditions are there.
Okay, sir. Thank you so much, sir. With this, we come with an end of this webinar. I would like to thank Dr. Rohit Moonka, sir, for providing a very good and emerging aspect of a new area of IPR, that's bioprospecting and its interrelation with traditional knowledge. Sir, I know students must have benefited a lot immensely with the same and the information provided by you. Also, I would like to thank our director, Dr. Mayuri Pandya, without whose motivation and constant support, we would not be able to organize such enriching and intellectual sessions. So, thank you, ma'am. I would also like to thank Faculty of Law family for their constant support in organizing this event. And lastly, students and viewers who have shown quite enthusiasm and patiently have heard the whole webinar. Thank you, sir. Thank you so much.
Thanks a
So, with
lot. Thanks. Yes. Thank you to all. Thank you to Mayuri ma'am also, and all of you, Vidhi ma'am, Urvashi ma'am, all the audience, students. Thanks a lot.
thank you, sir. So now we'll be ending the session, sir. Thank you.
All right.